Good afternoon and welcome to our live webinar on Facebook Live dealing with the topic of child custody, child maintenance and divorce. My name is Mohammed Abduroaf and I'll be presenting this today. Last week we were lucky to have it for all 5 days of the week. We had our webinar yesterday and we dealt with a few questions. There were about 5 questions that were posed live. If you have any questions you would like to ask me regarding child custody, child maintenance, and divorce, feel free to post it on our Facebook page. The actual Facebook page dealing with this would be the Advocate Mohammed Abduroaf Facebook page. If you are not on the current platform, please visit www.abduroaf.co.za/live. There is a redirect link taking you to the relevant Facebook page. Please feel free to pose any questions and I'll try my best to answer them. I'll keep an eye on the relevant Facebook page for any specific questions. Yesterday, after the webinar, we received additional questions. Many of them related to child maintenance, what happens during the lockdown. It seems to be a recurring question whereby I advise people that during the lockdown, if you lost your job and you're no longer earning income, you still have to pay child maintenance. Your child maintenance amount will obviously be dependent upon your means at the specific time and also whatever assets you own. Therefore, if you lost your job or earning less money, but you own a car, you own property, and so on, you need to ultimately sell that property, sell the car, sell your cell phone in order for you to pay your relevant child maintenance. I'm being general here. We also have to look at the specific needs of the child at the relevant time. The court order, if there's a court order in place and they cannot afford to pay the court order, notwithstanding everything, your inability to pay it based upon a lack of resources, a lack of income, a lack of assets, and so on, then you need to apply to the maintenance court to have the order revised, set aside, or substituted with a different order. But the long and the short of the matter is, notwithstanding the lockdown, if your child requires food, your child requires clothing, accommodation, and so on, if you lost your job, but you have assets laying around, it could be a bicycle, whatever machinery you have, and so on, you need to sell it in order for you to pay your child maintenance. If you and the other parent looking after the child can come to an agreement regarding a reduction in child maintenance, a short-term agreement, maybe for a few weeks, a few months, until things get better. If no such agreement can be entered into, we advise that you approach a maintenance court as soon as possible. If, for argument's sake, you require a month or two to get back onto your feet, I think it will be a waste of energy to approach a maintenance court for a reduction for a period of 2 months. You may only be heard in 2 months' time. If there is an agreement that you and the other parent has entered into regarding a temporary reduction of child maintenance, please record it in writing with specific schedules and information in it. So, for example, if you can no longer afford to pay the school fees or extramural costs or a cash contribution, you can only afford to pay half of it. Please explain in the schedule what amount you can pay and also how you are going to repay the arrear maintenance. If the maintenance order says you must pay R1,000 per month and all that you can afford is now R500 per month for the next 2 months, you have to pay back the balance. Moving on, if you have any questions, please feel free to post it on the Advocate Mohammed Abduroaf Facebook page and I will try my best to answer it. During the lockdown, many problems arose regarding contact rights. There were challenges. Parents who would not usually have contact with a child may have been forced to look after the child for an extended period of time. We all know that at the first 3 weeks of the lockdown, the minister said that the minor children should remain in the care of the parent who had the child at a specific time. And that was it. That was the law. If a parent would usually have a child only for a weekend and the lockdown kicked in, he or she had to now look after the child for a period of 3 weeks. Whatever the case may be, I can't remember now exactly how long it was, despite the fact that the child would have been in the primary care of the other parent during that specific time. or despite the fact that this parent only cared for the child for the longest ever for a period of 2 days. But the minister forced the parents to care for the child. They did not allow any movement of children. Later on, it changed. It said that there can be movement of children if there are court orders in place or parenting plans registered with the Office of the Family Advocate or parental rights and responsibilities agreements registered with the Office of the Family Advocate. If that was the case, and then you could move the child. If a police officer stopped you, a traffic officer stopped you, or any law enforcement person stopped you, you can show them the court order or the registered parenting plan or parental rights and responsibilities agreement, and they should allow you free access to collect or drop off the child. Then the regulation changed and it made it possible for the movement of children for parents who do not have those specific documentation, but then you required the ID documentation or the birth certificate of the child and so on. So you can imagine what happened, the problems that arose during the start of the lockdown, where parents who should have seen the children could not see the children, not because of anyone's wrongdoing, but because the law did not allow it. Then we came with another problem, whereby there were interprovincial movement of people was not allowed. If a minor child was in the care of, let's say, the father in one province, only for the weekend or for the week, lockdown kicked in, regulation said no movement of children across borders. That specific father or mother had to care for the child for an extended period of time, over a month, even though he or she would not normally care for the child for so long, or even he or she only cared for the child for a period of a week before that. Then you had to approach the court, and the court could have authorized a parent to enter into that specific province, showing the court order, removing the child, bringing the child back to where the child should be. Usually it would have been for learning purposes. If the child was in a specific province and there was no internet or whatever the case may be, or the child might have had a certain medical condition, and it would have made sense to remove the child and allow the parents to move over the province. Yes, of course, the possibility of the spread of COVID-19 would have been there, but the court would have obviously authorized it in the child's best interest, considering various regulations that you had to first test for negative for COVID-19 and so on. That was a challenge at the start of the lockdown, and the parents, hopefully, they would have resolved that. I have a live question. Let me read it out. Hi, please give advice. In 2018, I was abused by my ex-husband. We have a son together. On the 8th of December, I'll be taking him to the maintenance court. He has been paying maintenance, just not a consistent amount and date. I'm reading it verbatim. He was recently been jailed for theft and in January in rehab. I would presume it's either for drug or alcohol. And now he's demanding weekends alone with our child. Is it too late for me to report the domestic violence and court will give him weekend custody alone with our son? You all heard what I read now. There's an issue regarding an ex-couple. In 2018, she has been abused with a child, and now the father went to rehab, and now he wants to have contact during every second weekend. In giving advice to the specific person, you need to follow what's best for the minor child. And if you believe that the minor child will not be looked after well, or being reasonably cared for, or possibly in danger while it's in the care of the father, then contact should not take place. If there's a court order, and that's a challenge I have over here, if there's a court order that affords the father certain parental rights and responsibilities to look after, to have contact with the child every second weekend, but also you are believing that the child would be in danger or neglected and so on, you need to approach the court as soon as possible to vary the court order. Bring it to the children's court's attention as soon as possible. Tell the children's court, here is a court order, a divorce order stipulating that the father should have the child every second weekend. However, the father has been in jail recently for theft, as the facts are stating. The father is in rehab and so on. Now the father wants to be alone with the child on weekends. The court order allows it, but I believe it's not in the minor child's best interest. Under those circumstances, the Children's Court would urgently have to resolve this matter and make a decision. And what you're asking the court is basically to suspend the order for unsupervised contact rights, whereby you could possibly have contact with a child, maybe during the weekends, but supervised by you. Alternatively, there should first be an investigation as to whether or not the parent is capable and fit enough to have contact with a child. I'm giving general advice here. I'm not advising this person to take my advice. I could be totally wrong based upon the facts. I would have to ask you a lot of questions and look at certain documentation, look at the court order and so on. But the long and the short of the matter is, if there's a court order, the court order needs to be upheld and followed. But if you have a concern regarding the court order and the other party might place a minor child in danger, you need to approach the court as soon as possible for the court order to be varied and or looked at. And it's not too late to report domestic violence. You can do it at any time. And if the child is in danger as well, the domestic violence court can make an interim order that the other parent does not have any contact with a minor child pending the outcome of any other investigation. That's that question. If you have any further questions, you're welcome to add on to it, the Pacific live commenter. And anyone else watching this video, please feel free to pose whatever questions you have. And please share this video. Someone else might find it useful, especially if you're watching this video later on. Just a quick comment and a reminder, if you are watching this video later on, not at 12 p.m. on the 17th of November, let's say this evening or another day, please know that your comments will not be answered because all the comments are being done and dealt with live. We don't go back online later on and answer those specific questions. We do it all live. The commenter added some further information and said, and he tried committing suicide twice last year, December, and this year. Quite serious allegations being made over here. If somebody is committing suicide, that must be looked at. The question I have, and this is a general question to everybody listening here, you have to decompartmentalize matters. The issue is, if he is suicidal, does that automatically mean that the minor child should not know who his or her father is or have any contact with the father? The same way if somebody is abusing drugs, which is a criminal offense. But the question is that person using drugs in the presence of the minor child, despite he or she using drugs maybe in private? When he or she is alone with a minor child, is a child in danger if he or she is not using drugs at a specific time? A person must be very cautious. I'm not giving any advice here as to saying yes or no, but my advice is to you to look at the matter, broadly, looking at what is best for the minor child, but also compartmentalizing matters. Being suicidal is one issue, but doesn't mean everybody who is suicidal should not have any contact with his or her minor children. So those are important factors to bring to the court's attention for a social worker looking into this matter, and the social worker might decide that after consulting with a minor child, after consulting with the mother, after consulting with the father, he or she might decide, no, it is not best for the minor child to have contact with a suicidal person. Or the social worker might say, contact is important, is necessary. However, contact needs to be supervised, or contact needs to be limited, or as the case may be. Obviously, I do not know the age of the child. If the child is quite old, let's say 17 years old or 16 years old, things will be different as opposed to a child maybe 4 or 5 years old. The level of maturity the children have. If you have any additional questions, the live commenter, please pose it. As I said earlier on, these videos are all live, webinars are all live, and we answer those questions live. We do not answer it later on. Moving on. As I mentioned earlier on, during the lockdown, a lot of challenges came about regarding contact. And I can imagine those challenges are most probably still there. For the sole reason, firstly, because people are now being unemployed, people are working from home, kids are not going to school, or they're going to school every second day, and so on. So things are totally different as they were in 2019. We all know that. Therefore, the orders that were made back then, the maintenance orders, the custody orders, and so on, obviously took into consideration that school holidays were every year in June, every year in December, Easter holiday, and so on. And parents were generally working or taking holiday during certain periods of the year. if you believe that there is a change in circumstances, if you or there is a change in circumstances because now you are being unemployed or now you're working from home indefinitely, and working from home changes things. It makes things different under your specific circumstances. You are now able to collect the children from after school and bring them to your house because you're working from home. You're no longer working 20 or half an hour drive from your home. Although the court order says that you're only allowed to have contact every second weekend, but the minor child leaves school earlier. The other parent, who is a primary caregiver, is at work from 8 in the morning till 6 in the evening, as usual, as always has been the case. But because of COVID-19, because of the lockdown, you are now at home most of the time. You are able to collect the minor child from school at 2 o'clock, at 1 o'clock, depending upon the age of the child, what grade the child is in. Bring the child to your place and feed and look after the child and so on until the evening when you take the child back. Those days where the minor child is not attending school, the alternative days, despite the court order stipulating that you can only see the minor child every second weekend, but why can't you see the minor child during that specific periods as well, during those alternative days? Because the other parent is at work, he or she is working. Where I'm going to with this is things must be looked at, you must be reasonable. If there is a court order in place and the other party is saying you must follow this court order despite lockdown, I advise you to approach the court to have a specific court order re-looked at, and the court can make a decision regarding that, what is best for the child. I have another comment over here, and it says, reasonable force, please elaborate on this. A parent who wants to enforce contact in terms of an unwilling child to submit contact. I get a query a lot. Many people pose a question to me. They ask me the question, what if my child does not want to have contact with the other parent? Then I give them a counter question. Ask them, what if the child goes with that parent on his or her second weekend? Let's say I'm going to use the stereotype example, with father and mother. So I'll say the mother is a primary caregiver and the father is the one that exercises contact. The mother says here that the child does not want to go to the father. What must I do? Must I force a child to go? Then I pose a question. What if the child does go with the father and he takes him to McDonald's and his and cousins at his house, and the child is enjoying his or herself at the father's home? Now the child says, no, I do not want to go back to mommy. I want to stay by dad because life is good here. Do you listen to the child? Or do you use common sense? Or do you as adults, as parents, decide what is best for the child? It's very important. You do not necessarily have to follow what the child says. Life will be chaotic. Tomorrow the child says, I do not want to do homework. I do not want to do this. I want to go visit my friends. I want to move out of the house. I want to come home at 2 o'clock in the morning. You need to be responsible as adults. Therefore, I do not advise parents to listen to the child. If the child needs to go to the other parent, and there's no social welfare issues involved, and you haven't gone to the courts to change the order, then the child must go. You need to use a reasonable force to let the child follow. And the same way, the child must come back to the mother. It's Sunday evening, it's 6 o'clock in the evening. The child said, no, I do not want to go to school the next day. I want to stay by dad's house wherever I am, and I do not want to go back to mommy. The child must go back to mom. That's how it is. You can't let the child rule your life. But if you believe the child will be in danger, and the child has good reasons not to go to the other parent, they say there's a step parent there or there's some abuse happening, then you need to go to court and you need to vary the order. I always say follow the order the best you can, but if the order is problematic under the circumstances, then you need to approach the court. I hope that sorts that issue out. The first commenter says further, the child is 3 years old. I do take my child to his grandparents' house where he is allowed to spend time with our son, and he is allowed to visiting our son with me in the presence, but is demanding weekends alone with a child. So the child is 3 years old. The suicidal father, the drug addict who's in the rehab, or he might not be a drug addict anymore, and the one that was in jail, based upon the previous facts, he does see the child because the mother takes the child to the grandparents. My advice is still the same. If there's a court order in place, it needs to be followed. Alternatively, immediately, urgently now, approach the court and have the court order set aside. That should be able to resolve all issues, or set aside or vary the order. Another commenter, How can a person stop a tit-for-tat protection order game? For instance, I have one against my husband. He has applied on 2 occasions to try to get against me. This is all based on falsified information. That needs to be brought to the court's attention. The court cannot grant a protection order against you or in favor of you unless there's evidence. Yes, we all know that an interim protection order can be granted based upon basically hearsay evidence, or not hearsay evidence, untested evidence, one-sided evidence. That's what I'm looking for. And that's a bit of a problem. But if that is the case, immediately anticipate the return date and have the matter heard. The magistrate cannot make a final protection order unless there is information. And keep a record of all these applications and interim protection orders, final protection orders, and so on. Keep a record thereof. If the person makes another application in the future, you can tell the court, this is another baseless application. Application number 10. Application number 1, 2, 3, and 4, and 5, and 6, 7, 8, 9, and 10. Here, all of them, another baseless application. But at the same time, the court has a legal obligation to look at the application, because what if application number 10 is actually a legitimate application? And the comment goes further from the live commenter, the second person. But what is the reasonable evidence that the child has been through so much trauma that makes them not wanting contact with other parent? It's not for you as a parent to come to those type of psychological legal conclusions. You need to follow up with a process if there's a court order in place. Therefore, if a social worker and a psychologist made that decision, or if you are of the opinion, then you need to approach the court. I'll keep on saying that. Do not on your own decide to limit contact. If there is an allegation made today, or the child is, I do not want to go to the dad because I'm being abused, then immediately go to the police station, immediately go to the social workers, immediately go to the children's court. Do something now. Don't you play judge, jury, execution, and so on. I do not advise people to do that. And we have another comment. Thank you, Advocate Abduroaf, for your valuable feedback. If there are any further questions, you are welcome. If there are any further questions, please feel free to pose it. These videos are usually about 20 minutes long, and I'll try to deal with them as the questions come. If you have no further questions, and the time now is 24 minutes, so we went over a bit of time. Thank you for all those who have posted your questions. I appreciate it very much. If you have an opportunity, please share this video on Facebook, and I'll see you tomorrow. Thank you very much. Have a lovely day.